What does the Family Educational Rights and Privacy Act, or FERPA, say about the practice of peer grading? When does something become an educational record protected under FERPA? Do you think the people who wrote FERPA knew we were going to call it FERPA? Because, let's be honest, they probably could have come up with a better acronym.
It's such a weird, it's a weird word. It sounds so silly saying it, FERPA.
It does, yeah. No, I really don't like it. It kind of makes me think of like the Oompa Loompa song. FERPA, derpa.
Well, thank you. I had not thought of that. And now every time I hear it, that's what I'm going to think of. Great. Yeah, it's a really silly acronym, but
you're welcome.
Yeah, so this is actually our first episode about FERPA. We're going to say this a lot today.
Yeah, which is unfortunate because we just, slammed the name.
I know. So what is FERPA? FERPA is the Family Educational Rights and Privacy Act. This is the law that's designed to protect the privacy of student records. So what information is protected under FERPA and what isn't? Today's case involves a parent who took issue with a teacher's use of peer grading, saying that it violated their child's privacy and was embarrassing to their child. So this, today, is the case of Owasso Independent School District versus Falvo. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Hey everyone, welcome back. Before we jump into today's bell ringer, I just want to remind everyone to please like, rate, and review Chalk and Gavel. If you're watching this on YouTube, like and subscribe, give it that thumbs up. It's so helpful for us to spread the word about the show and to get picked up by all those algorithms. We also have a teaching guide at chalkandgavel.com if you want to use Chalk and Gavel for your teaching or for professional developments. Or if you just want to find an episode about something that you're interested in, it's all up there. You can also support us on Patreon at patreon.com/chalkandgavel. $2 a month goes a long way to helping Jamie and I sustain this show. Can't tell you how much we appreciate all of your support. So with that, Jamie, what's our bell ringer?
All right, so today we've got a recent decision from the Fifth Circuit Court of Appeals. So the Fifth Circuit is Texas, Louisiana, and Mississippi. All right. Okay. And this decision came back at the end of May, and it was an en banc decision. So just a reminder.
We haven't done an en banc in a minute.
Yeah. So that's everybody, all the justices or all the judges who serve on the Fifth Circuit Court of Appeals, they all weigh in on the decision as opposed to just three.
Yep. Typically. Usually it's a panel of three.
Yeah. So this was 17 judges, and they ended up delivering a 10-7 ruling. So this is the case of Little versus, I want to say Llano County. It's Llano, and that's near Austin, Texas. So this case, it wasn't a public school case, but it was a public library case. This was a case about a public library that removed 17 books that community members said were inappropriate for one reason or another. Very similar kinds of reasons that you've probably been hearing about in the news for the last number of years in terms of book bans. This one, this is a CRT book, or this book, is pornographic, or this book
inappropriate
has
materials. Yeah,
inappropriate, or LGBTQ, or things like that. Those kinds of
sexually inappropriate, right?
Yeah. And so what makes this very interesting is that the decision here kind of flies in the face of long-standing precedent on the issue.
What did the majority decide?
So the majority said that removing books from a public library does not equate to banning them. Okay?
Oh, yeah. Okay.
Well, okay. So here's basically the parents that challenged the removal of these books. said the same thing that was kind of decided in the big major Supreme Court case, the PICO case from the early 80s, which is people have a right to receive information. They have a First Amendment right to receive information.
Right.
Right? And banning books takes away your
Denies
right.
them that right. Yeah.
Yeah. To receive information. And that was the decision that was made in the PICO case, which is a U.S. Supreme Court case.
Yeah.
And there
From
was,
what, the 80s?
From the early 80s. I think it was 82 maybe. And then, interestingly, there was also another case in 1995 in the same Court of Appeals, the Fifth Circuit Court of Appeals, that basically said the exact same thing. And one of the other things that it said is it's really important to look at the motivation behind removing books. And there have been a lot of cases. Counts versus Cedarville is another case about removing books from or restricting access to books in a library that have basically said you can't remove books just because you disagree with their content. There has to be some other very valid reasons.
Right. And that's what PICO said. Like, PICO was the school library case at the Supreme Court. And, you know, it was a plurality decision, but it seemed to be that like all of the justices agreed that like removing a book for purely ideological reasons would violate someone's First Amendment right to receive information.
Right.
And that's kind of like, you know, West Virginia v. Barnett did the same thing. That was the flag salute case from the 40s. Where you couldn't require students to say the flag salute or to stand up and salute the flag because doing so would promote orthodoxy or like basically require students to affirm a belief, and that's beyond the authority of government. So like it's two sides of the same coin to me.
Yeah.
But it sounds like here the court said that like just taking it off the library shelf doesn't implicate people's First Amendment right to receive information because they can still get it somewhere else.
Yeah,
is that the argument?
Yeah, that's their argument, that they can go on Amazon.com and buy the book, or they can go to a bookstore and buy the book. Like
borrow it from a friend. Sure.
We're not Fahrenheit 451ing anything is kind of what they're saying, even though they didn't use. Yeah, they didn't use that language.
I like it as a verb though.
You like that?
That's pretty good. Yeah. I used to teach that book. It was so much fun.
So that's basically it. They're saying we're not banning the book. So that doesn't violate your right to receive information.
Interesting.
And you know, even though this doesn't have anything to do with schools, this is a public library case.
Right, but the logic is easily extendable to schools, right?
Easily extendable, and it basically what it does is it makes it far less likely for somebody who takes issue with books being removed from a school library. It makes it far less likely for them to be successful if they wanted to challenge it, at least in the Fifth Circuit.
Right. Yeah. So this is going to make it a lot less likely that you'll succeed in getting something put back on the shelf if it was removed for, you know, some problematic reason.
Yeah. And what is problematic and why the book was removed isn't part of the analysis anymore, which is very, very interesting, because all of the cases that we have seen, almost all of the cases that we've seen so far has said, you know, no, those should be factors.
Right. And that's what the Supreme Court said in Barnett. That's what it said in PICO. There's been a ton of cases that have said, like, you can't promote orthodoxy. And now we've got this decision saying, like, well, it doesn't implicate your right, so therefore we don't need to look at those reasons.
Yeah.
Oh, wow. Yeah. We'll see if so this is en banc. So, you know, it'll probably get appealed to the Supreme Court if the Supreme Court wants to take this up. Yeah, that's interesting. Because, it does seem to be contradictory to how I understood the state of the law.
Exactly. Listen, if it does get appealed to the Supreme Court,
we'll cover it then.
I will say my initial response to that would be it's probably going to be very unlikely that they would take this up because, you know, they do have a tendency, or at least they have in the past, had a tendency to avoid taking up too many controversial issues at a time. But what we've seen lately is, I guess, they're not that opposed to taking up a lot of controversial issues.
I have given up trying to predict which cases they're going to take or not take.
Yeah. And there's so much, there's so many things we could be talking about in these bell ringers.
Mm-hmm.
And we will, I promise you, we will get to as many of them as we possibly can.
Maybe we should do an episode that's just all bell ringers all the time.
All right. Well, so that's today's bell ringer out of the Fifth Circuit, which again is Texas, Louisiana, and Mississippi. And, if anything materializes at the Supreme Court level with this case, we will let you know. Okay. You ready to dig into some FERPA?
That's so unfortunate. Yes, I am.
All right. So today we're covering Owasso Independent School District versus Falvo. This is a Supreme Court case from 2002, all about FERPA, the Family Education Rights and Privacy Act. So FERPA is one of those laws that I would say is probably pretty difficult to understand and navigate.
There's a lot of misunderstandings about FERPA, what it does, how it works.
Yeah, it's very similar to the copyright law, right? Like we talked about in a recent episode. This is about what information should be protected, what information doesn't need to be protected. How do we sort of respect people's privacy and things like that? That's what FERPA is all about. So first, it was enacted back in 1974, long before the use of all of this advanced student information system technology that we have, electronic grade books, shared file systems and documents, and all the stuff that we use so regularly and are so deeply integrated into school systems and student work and all that stuff. FERPA came around long before any of that stuff existed, right?
Right. Yeah. You're talking about pen and paper, lithograph machines? Is that where we were at that point?
And mimeographs. And I will say, this is really dating myself here, but the mimeograph stuff and like I was one of those kids. I mean, I think most of us from the 80s could probably say that, when a teacher would walk into the room with the sort of hot off the presses photocopies, and we would just go, oh, smell them because they came from those. God, I'm old.
Yeah, no, it has a very specific smell.
It does. Anyway. So this is like, filing cabinets and, all that stuff.
Yeah.
Paper.
Before the cloud.
Before the cloud. Yes, exactly. And, it's FERPA has been amended here and there, but not a ton. Like the core of the law hasn't really changed very much, even though all this technology has. So what has happened along the way since 1974 is we've had to kind of figure out how FERPA applies to this new evolving landscape, right?
Right. And that's been a huge challenge because this law is so antiquated and things have moved so quickly technologically that we're basically kind of stretching and pulling this law to cover contemporary situations. And it's not always clear exactly how those new situations fit within this law.
Yeah, and to make it even more messy and complicated, FERPA is at its core is not the most straightforward kind of law. Thanks a lot, Congress, once again.
Our copyright case, right?
Exactly, like the copyright case. There's a ton of ambiguity in the rules.
Mm-hmm.
And when you've got ambiguity, that leads to confusion and that leads to concerns about, I don't want to accidentally, break the law, so I'm going to overreact or I'm going to just be way more cautious, right, than I might need to be.
Yeah. There are no bright line rules here.
Yeah.
Right?
Yeah. But, look, that's what we're here for. We're going to help you try to make sense of this. So before we go into the facts of the case, let's just quickly talk about what FERPA is. Let's unpack this and say FERPA as many times as we can.
Right. Unpack the FERPA. Unpack FERPA.
Yes. Let's unpack it.
Yeah, let's do it. So FERPA protects the privacy of student records. This makes a lot of sense. Like schools are constantly dealing with sensitive information about students. We know their demographics, their addresses, phone numbers, information like disciplinary records, everything to their grade, their GPA, whatever it is. Schools have a ton of information about students that, we probably don't want everyone to know. And so FERPA sets out the standards for schools in managing and disclosing those records. That's pretty straightforward, but there's a few kind of key provisions of FERPA. So it requires schools to have policies and to provide yearly notices to families regarding the maintenance and disclosure of educational records. And just to give you an example of that, like the policies have to include a record of who accesses the student's file. And I think that alone, like that,
it's like this chain of evidence kind of.
Right, exactly.
Right?
And that's kind of what it is. Like you want to know who's accessing it, but like that shows you how antiquated this law is, right? Like this is assuming that there's some like permanent record, right? That like this is going to go in your permanent record that you can just like take out of a filing cabinet and sign out like, oh yeah, I took it out on the filing, I took it out of the filing cabinet.
Which is how they used to do that. Like there was a sign out sheet and everything. And I think in many places it probably still exists like that, because, I think it would probably take a lot for some school districts and some locations to sort of, jump onto the technology.
Right. But then compare that to like an online grade book where, if I've got access to it because I need access to it, like I just get on there. Yeah. Right. Like, and so like, it's one of those things
automatically tracks who's logging in and who's not and all that stuff. But anyway, yeah.
Or like, my email, right? Like, that's an educational record in some situations. Right. So like, but it's not maintained in some permanent record.
Right. Exactly.
So that's just kind of say like schools have to have policies and procedures. Some of them are more technologically advanced than others.
But, I would say, listen, signing out the materials, knowing who has accessed those materials I don't see that necessarily, at least as far as FERPA is concerned, as an antiquated kind of thing. And I think because one of the reasons is that FERPA requires that the only people who can access those records are people who have a legitimate educational interest in that particular, like just any teacher can't access some kid's record. They have to have a reason for it. And so I guess in some ways it's really important to know who has accessed those records.
It is. And like the spirit is still true, right? Like, but it's an example of like how these rules and procedures and the intent behind them have to be adopted to existing technology. So like if you've got an online grade book, every teacher shouldn't have access to everybody's grade book, or like I can only see the students that I've got and I can only see their grades in my class. Yeah. Right. And that's built into the software. So like Jimmy, to your point, like it's not to say that those sorts of requirements and like tracking aren't done. It's just, it's done in a different way. Right.
Yeah. Because it's done more on the back end than
exactly.
The front
right.
End.
Yeah. Because at its core, Jamie, to your point, like FERPA says that educational records and students' personally identifiable information, or PII, has to be kept confidential, and it can't be released without consent unless there are certain exceptions. And FERPA also gives parents the right to inspect, and this one's always really interesting, request corrections to their kiddos' educational records. So it's a don't give this to other people, and also I, as the parent, can come in and look at everything, make sure it's accurate. And if it's not accurate, I need to have some process to challenge the accuracy of those records.
Right. Yes, exactly.
Right. And then, Jamie, you mentioned some of the exceptions to FERPA. And there's kind of two big ones that are really relevant to educators. First is that schools can disclose what's called directory information as long as they provide notice of how they define that and allow parents the opportunity to opt out of that disclosure. So directory information typically includes stuff like your name or students' names, their addresses, telephone numbers, date of births,
grade level,
what they're studying, what extracurriculars they're in, when they attended school, what degrees or awards they got, that sort of stuff. So like,
and if you're, if you're
that would be in a yearbook.
Totally. And if you're, if you've got kids in the public school system or whatever, chances are you're well aware of this, because this is a very sort of front-facing kind of, like, you will every year you're going to get an email that says, we publish a directory and blah, 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 right? And here's how you can opt out and do all that stuff. So
hopefully they get it every year, because that's what the law says.
That's what the law says, right?
And so, there's other exceptions to when schools can disclose educational records. Jamie, you mentioned the legitimate educational interest, because that's kind of the biggest one. Basically, like if somebody at the school needs to know it for an educational reason, because they're either teaching the kiddo or, they're supporting them, like, then yes, that is something that FERPA is going to allow. There's other limited exceptions. So like if the student's trying to enroll in another school, that school can get their records. exceptions for audits and evaluations. There's exceptions for health or safety emergencies or for law enforcement purposes. There's also disclosures that are allowed for research purposes. There's some requirements there as well.
Yeah.
Accrediting agencies or organizations who need it to make sure that people are doing what they need to be doing. And then this was actually an amendment in the early 2000s. There's also an exemption for military recruiters to get information so that they can reach out to engage in recruitment efforts.
Oh, interesting.
Yeah.
That's interesting.
Yeah. So that's FERPA in a nutshell, right? Like there's obviously a lot of nuance within all of that because there are specific rules for everything we just talked about. But we mentioned that like there are no bright line rules here. And one of the kind of areas where there's not a lot of clarity is in how FERPA defines education records, because that's the key piece, right? If it's an education record, it's subject to FERPA and it's protected. You can't disclose it. There's a bunch of other requirements.
Right.
If it's not an educational record, then it's not covered by FERPA.
Yeah.
And schools can kind of do, whatever they want with that, obviously within reason, because there's other stuff you got to be aware of, like torts related to defamation and invasion of privacy, et cetera, et cetera, et cetera.
Right. But at least as far as FERPA is concerned, right? Yeah.
Right.
If it's not considered an educational record, then it's not covered under FERPA. So then the big question is, what's an educational record and what isn't? And that's what courts have kind of wrestled with on and off since FERPA came out in 1974. As old as I am, that was before my time. And so this particular case kind of hinges on that question, right?
Right. How do we understand that term?
Yeah. At least as far as peer grading is concerned, because that is the issue in this particular case. The facts in this case are really straightforward. Okay. We got a parent who had 3 kids in the Owasso Independent School District. Again, this was probably back in the late 90s, roughly, because the court decision was 2002. So what happened was that school district used, or teachers in the district used, the practice of peer grading. Okay. So here's what happened. Teachers would ask students to trade tests, papers, assignments, things like that. And then the teacher would stand there and explain the correct answers, and all the students would grade each other's works. Next, the teachers would have students then trade their papers back and verbally report their scores to the teacher so that the teacher could record it in the grade book. So to me, it sounds like what's happening is the teacher is just like sitting at the front of the class saying, rather than me go through these 20 papers, and grade everything. And listen, I've seen it. I would probably, I can't think back to when I was a teacher, but I can't say with confidence that
you didn't do this.
Well,
you were a math teacher, and I feel like math would be the perfect place for this, right?
Well, yeah, we got 50 questions on this test, and
and there's
37,
a clear right
46,
answer.
X, X is 9, X, it's a quick anyway.
Well, I remember this as a student, right? Like, I did this all the time as a student.
Yeah, totally.
And I'm kind of a competitive person, and so like
knowing
I was
what everybody else's scores are.
because I could be like, oh yeah, no, I got a higher score than you.
Yeah, I mean, I don't know if I was competitive. I was just interested in knowing where I stood relative to others, And of course, if I didn't do very well, then I felt bad.
And that is the argument here, right? Like, and that's the second piece of this.
It's part of the argument. Yeah.
Yeah. Well, yeah. Cause like, if you're doing well, it's one thing, like, cool, awesome. But if you're not, you're not succeeding on the test, or if you're not doing as well as your peers, like, if other people know that now,
that
like,
can be embarrassing.
There's some stigma, there's some embarrassment.
Yeah. And that's what the mom was arguing here.
Right. Especially if you have to like report your score out.
Yeah.
Because I remember doing peer grading, and, the only person who knew your grade was the person who graded it. And then you just passed them up the row, and then the teacher would collect them and record them. It wasn't this like call out your grade. Because that almost feels like, I don't know, like a social shaming. Maybe that's not it, but like. It
was like that has been a common practice, not just the peer grading piece, but like the posting of grades, like long before the 80s. That's how students often found their grades, is they would go up to the classroom door the day after the exam that they took, and everybody was just listed with the grade, the corresponding grade, like that was a pretty common practice for a long time. Anyway, so that's what happened in this class, is that, they were peer grading and they were calling it out. And so, the parent in this case thought that act of peer grading was violating their kid's privacy. And this was an embarrassing sort of act for their kid to experience and go through. And so she asked the school to ban the act of peer grading. And the school said no. And so what happened?
So she filed a lawsuit. And the parent here is arguing that peer grading violates FERPA because it discloses students' grades to at least one other student without parental consent. So if that grade on that assignment is an education record, the parent here is arguing that is covered by FERPA, and you can't disclose that to other students in the classroom without my consent. And the school district obviously disagreed with that because they liked the practice of peer grading. I imagine peer grading probably has a lot of educational benefit, right? Like, not only does it save teacher time, but it's a learning activity too for the students, right?
I would say if it's done properly, it
right?
Could be, does it have to be associated with the actual grading part? Maybe,
True.
Maybe
you could
not.
just review it, right?
I think you have to really kind of think about what's the objective here, and what's the best way to reach that objective. And the only thing I would say is if your main objective is to save yourself time, first of all, I get it that we are incredibly pressed for time as teachers. And, I am not saying that we shouldn't look for any opportunity to save ourselves some time because the constant compounding of mandates and I've got to do this and do that. And they're telling me I have to blah, blah, blah. I get it.
Right.
But I am only mentioning that as sort of a word of caution that if your educational aim here is to save yourself time, just be careful because that might not be, from a student perspective, the best, most educative kind of plan, right?
Sure. But, I remember, as a student, like you would ask like, okay, what's the right answer? And you'd go through it like that. And like, it was.
Again, that's different.
Right.
Like if it's just calling out the answers to a multiple choice test, by saying 1 is B, 2 is C, 3 is D, like that's,
yeah.
And I've seen that happen before.
Which begs the question, why do you got to trade at all? Right? Like you trade so that people can't cheat.
Yeah. Unless you happen to trade with your best friend and you guys have a deal going.
A little wink, wink, nudge, nudge.
Yeah.
Yeah. Right.
Anyway.
But luckily the court doesn't care about any of that. Because courts are very deferential to schools in a lot of regards, and they're just trying to implement FERPA. And so the district court looked at all of this, and so we're in the U.S. District Court for the Northern District of Oklahoma, and the school files for summary judgment and wins.
Okay, so they're basically just saying, listen, this isn't a violation of FERPA. It's very clear that this is not a violation of FERPA, so we win. We don't even have to go through all the rigmarole.
Yeah. And for the trial court, student grades on individual assignments don't fall within FERPA's definition of educational record. So no harm, no foul here.
Interesting.
At least under FERPA. Maybe the educational harms that we were just talking about. Sure. But the court, meh.
Okay. So the parents were totally satisfied and went on their way.
And so they appealed it to the 10th Circuit.
Oh.
Yep. And they had a bit more luck. The 10th Circuit said, you know what?
No, they
You're
flipped
right.
it.
Peer grading does violate FERPA because recording the grade on the assignment is an educational record protected under the Act. If a student's final grade in the class is an educational record and everybody agrees that's an educational record, then it makes sense that the individual grades that make up that final grade are also educational records. Because if I knew all of your individual grades, I would know your final grade. Yeah, makes sense.
Okay.
That was the 10th Circuit's rationale. And the school district now is very unhappy with that because they're like, you know what? We actually kind of like this practice and we don't think we did anything wrong. So we're tied 1-1 and the school district appeals to the United States Supreme Court.
Okay. And again, this was 2002.
2002.
Okay.
Yep. Yep. So the court takes it up, and the question that they're asking themselves is whether or not peer grading creates an education record protected by FERPA.
Okay.
So here's the squishy definition of educational record. You ready? So FERPA defines education records to be, quote, records, files, documents, and other materials containing information directly relating to a student which are maintained by an educational agency or institution or by a person acting for such agency or institution, end quote.
Okay.
Two crucial things in that definition. It has to be related to a student,
Okay.
meaning that it has to be about that student, right? And it has to be maintained by the school. Those are kind of the key things that make something an educational record.
Okay.
It has to be about a student or involve a student. It has to be maintained.
So then the question becomes, when does a grade become an education record, right?
When it becomes maintained.
When it becomes maintained.
Yeah. Isn't that helpful?
No. It's not.
And you're exactly right. Like that's what they're fighting over, right? So, grades are obviously relating to a student, right? Like that,
Sure, yeah,
that part is
that seems
a
easy.
slam dunk.
But the other one kind of seems slam
It's
dunkish
really-
to me too. Like, is the teacher not part of the school? Like, they're maintaining that.
But has it gotten to them yet? That's the question.
Really?
One of the arguments. So like there's a spectrum here, right? And on one end of the spectrum, the argument was that educational records under FERPA are just the institutional records contained by that are collected by some central records keeper that are final institutional central office kind of stuff.
Yeah.
And so they that argument was basically it's only the stuff in the permanent file
Okay.
that is kept as a matter of course. So
Right.
things like final course grades,
Yeah,
GPA, standardized test scores,
Discipline
attendance records,
infractions.
counseling
Yeah,
records,
yeah,
disciplinary
yeah,
actions,
yeah,
all that
yeah.
stuff.
Yeah.
It's only your permanent record that is actually an educational record under FERPA.
Yeah.
And so everyone kind of agrees that yes, that is an educational record. It's the question of how far removed from that do you have to be still be something that is an education record? And so we go down to teacher grade books, right? So if the final course grade is an educational record, like a student report card, totally an education record.
Right.
It's about a student maintained by the school.
Yeah.
What about the grade book?
Okay.
You record your grade
Yeah.
grades in that little, before they did it on computers.
Yep.
And the parents here are also arguing that, if the final course grade is an educational record, then all of the individual grades are educational records. The grade book's an educational record. So are the tests.
Mm-hmm.
And the court sidesteps the question about the grade book. They just don't want to address that. They assume for purposes that, yes, it's an educational record because they think that the assignment itself is not an educational record because
Why? Yeah.
it's not maintained by the school.
Okay. Explain that to me.
All right. So think about the process. I grade your paper.
Yeah.
100%. Knocked it out of the park. I, as the student, am now holding that record, right?
Yeah.
I'm not the school.
I mean, I get that, but it seems, at least as far as the spirit of FERPA goes, that, I'm not making a statement about whether or not, the act of peer grading is, ethically
Or pedagogically, right?
pedagogically appropriate or whatever. That's not what I'm saying. I'm just looking at it as far as the law is concerned. And I think that that's a little, I'm not sold, I guess you could
would
say.
it help if I gave you a dictionary definition of what maintain means?
No, because I don't really
well,
care.
I'm going to. Because that's what the court did, right?
All right.
So the Supreme
They
Court.
like using the dictionary.
Yep.
That's fine.
So they cite a definition from the Random House Dictionary from the 80s, around the time that FERPA was written. And it says that to maintain is to keep in existence or continuance, preserve, retain. So for the court, the grade for peer grading isn't maintained because it's a transient thing, right?
Yeah. It's in motion.
It's in motion. Yeah,
It hasn't
exactly.
been
That's a good way to
received
think
by
about
the
it.
maintenance thing yet.
Mhm.
And
Yep.
And I get that. But again, if we're talking about sort of the spirit of FERPA, which is, one could argue, we are doing this to protect people's privacy, right? Then we're not really doing that by, it doesn't matter where in the process does maintenance start,
Mhm.
right? Because the cat's out of the bag by the time it gets to that point. And so basically what the court is saying is, if any of this information comes out before it gets to that maintenance cutoff place, then it's fair game and not covered under FERPA. Listen, I think there's a lot of circumstances where I think that that's perfectly fine. if we're talking about, I don't know, I'm trying to think of some hypothetical, like a discipline related situation where some act or something that happens that's very public, and the school's response to that act is very public just by nature of, how it all goes down. Somebody does something right in the hallway and is caught by, an administrator or something in front of a whole bunch of people. And like, obviously those kids know that kid is getting in trouble or something like that. I don't think it's realistic to consider that a violation of somebody's privacy because
right.
Like it just,
well, and it has to be a record, right? Like it's got to be something that is like stored in a tangible form or electronic form.
Or getting, so getting a tardy slip, like an actual physical tardy slip, getting that handed to you as you're walking through the hall in front of a whole bunch of others, and that tardy slip is going to be applied to your record. Like, I'm not saying that I would consider the act of being handed that tardy slip in front of a bunch of people a violation of your privacy. But I think this goes back to what we were saying before about pedagogically, is the act of peer grading and reporting these grades out the best move?
Right. Maintained is in the definition of educational records. And like, that's one of those things where it's like, there's the spirit and then there's the words.
Yeah.
And courts are bound by the words.
Yeah.
Right. And that's kind of where they start and often where they end. And, maybe there's other things that help them understand what those words mean. But, textualism is a very dominant form of statutory interpretation right now. So we gotta work with the words we got. So like, Jamie, to your point, like I see the spirit of it and like, we're trying to protect student privacy. And like, there's also kind of some ethical components here where like, one of the big things in a lot of teacher code of ethics is to not subject students to like unnecessary embarrassment.
Yeah.
Right. Like, cause that's something that is really important. But, the FERPA, while it's trying to accomplish those things, is bound by the language of the statute. And this just all highlights the challenges in drawing lines, right? Yeah. And that's the challenge that they're having here is like, okay, well, related to a student, there's line drawing issues there I've got to figure out. And there's line drawing issues in this idea of maintained. Is it something that like has to be in a permanent file, or is it just something that like I saved and I keep in my desk drawer and that's enough?
Yeah.
Right. And there's got to be something between those two things. And for the court, like peer grading falls on the not maintained side of that line because it's a very just kind of transient thing that isn't kind of, kept in existence or continuance, right? Like to go back to that different, that definition. And also like students aren't acting on behalf of, they're not like agents of the school. So like, there's also that issue there too, where like, are they even really subject to FERPA because they're not the school itself? So even if they were maintaining it, it's not necessarily the school maintaining it.
Right. And what happens if like the teacher decides, this is just an activity that we're doing, I'm not going to apply these grades to your final grade or something like that? Then, then you also have another situation where like that's even further removed from what could be considered an educational record.
Yeah. And reading the opinion, the court is always hesitant to turn molehills into mountains.
Yeah.
So like this is in the early 2000s or, it started in the late 90s. FERPA had already been around for 25 years.
Yeah.
And one of the lines in the Supreme Court's opinion is like, they engaged in peer grading, an activity conducted by schools all across the country. And so it was one of those situations where like, you can kind of read behind the lines where the court is like, look, this old law probably doesn't prohibit this thing that we've always done.
Yeah. Yeah.
And so they're reluctant to read it in new ways.
We're not going to be the ones to, start upending school norms and things like that, even though 20 years after that, they have no problem with it.
In some cases, right?
Yeah.
But so all 9 justices agreed in the outcome. They agreed that
unanimous.
The school should win.
Okay.
Not unanimous, though.
Because there's 9 different opinions.
No, there's only 2. So Justice Kennedy wrote the majority opinion that 8 justices joined. Okay. So Kennedy and 7 other justices joined the majority opinion. Justice Scalia, though, wrote a concurring opinion. He agreed that the school should win, but
for
he
different
took
reasons.
Some issue Well, no, not even for different reasons. He
Oh.
took issue with how the majority characterized maintain. For Justice Scalia, he pushed back on the court's implication that only records that are kind of like centrally controlled by some like central records custodian are maintained within the meaning of FERPA. Because that's what the government was arguing in this case. The US government was arguing that like FERPA only covers students' permanent records. And there was some language in the court's opinion, the majority opinion, that kind of suggested that like, it had to be something like really, really permanent. It had to be like you took it and you put it in the filing cabinet. You did some affirmative action to like make this thing a maintained record. And Scalia pushes back on that and says like, no, like maintain means you keep it in the ordinary course of business. That covers a lot more stuff. And that is actually kind of the current interpretation. So like Scalia's more kind of, I guess, expansive understanding of what maintain mean is kind of where we're at.
Got it.
So like, FERPA obviously covers the permanent record, but it also covers everything that all the records, that schools maintain in the ordinary course of business. So like your emails that are stored on a server somewhere, those are maintained by the school district in the ordinary course of business. So if those emails pertain directly to a student,
a parent could
that's
have
an
access
education
to
record, and you're going to have to disclose that to a parent.
Yep.
Yeah.
Yep.
Which, goes back to our old advice. Dance like no one's watching. Email like it's going to be read in court.
That's right. We haven't tossed that one out there in a while, man.
No, I'm glad it came up.
Yeah. Nice. Well done. Well, that's FERPA in a nutshell. That's our first FERPA case.
Yeah.
First PA.
Maybe we should spend the rest of the time like coming up with a better acronym because there's got to be some good ones out there because FERPA is just not good. It sounds like this would be a very good job for AI to kind of come up with something. Yeah.
fun.
Let's see what GPT comes up with.
All right.
All right, let's see here. Ooh, what do you think about GARD, the GARD Act? Governing use of academic records and data.
Oh, well, that seems appropriate.
That's good.
Yeah.
Straightforward.
Yeah.
It's protective, right? Like we're guarding their data.
It doesn't sound like FERPA.
No, it doesn't. Oh, here's a good one. How about the Buzzkill Act?
Oh, come on. Buzzkill?
You ready?
I can't wait to hear this one.
Bureaucrats upholding zealous zeal to keep kids' info locked in legal.
Ha! You're kidding. Oh, man.
All right. I'm going to write my congressperson. I'm going to write my congressperson to reauthorize FERPA as the Buzzkill Act.
That would be awesome. That would be awesome. All right, Chris, what's our homework today?
Your homework, I think, is to write your congressperson to rename FERPA the Buzzkill Act.
Yes, let's make it a thing. Yeah, let's
whichever you prefer.
Okay. What else?
But your homework is to find Chalk and Gavel wherever you get your podcasts, like, rate, review. That's so helpful as we continue to grow the show. If you're watching this on YouTube, hi. And, like, comment, all that fun stuff. It really promotes us in the algorithms, which is a huge part of getting seen.
Yeah.
You can also find us at chalkandgavel.com. You'll find our teaching guide up there, as well as a feedback survey if you want to kind of let us know what you think of the show and if you have any comments, or if you have ideas for cases or topics we should cover.
Totally.
Always looking for those.
Yeah.
And you can see our teaching guide up there. I'm not sure if I already said that or not. It all blurs together every time we do this. But you can also find our Patreon, patreon.com/chalkandgavel. Your support means the world to us, and we'll keep doing this as long as you all find it valuable.
Yeah. All right, everybody. That does it once again. We'll see you in a couple of weeks. Bye.